is a sage. So I just, she's my muse in so many ways. And
Blake Lively versus Justin Baldoni, a battle many thought would explode in court, might not even begin. Blake was preparing for a major legal showdown, but Baldoni's legal team has made a move that could end the case before it starts. They've filed a motion to dismiss the lawsuit with prejudice, meaning Blake could be permanently barred from refiling it. The situation has reached a breaking point. At the center of this conflict lies a complex clash between California and New York laws, a small but critical technicality that could determine the entire outcome. One wrong interpretation, and the judge could shut it all down with a single ruling, ending the case in an instant. Behind the scenes, tension is rising. "You've retaliated against Baldoni. It's already out there," one insider remarked. The complaint might be gone, but this isn't looking good. Whoever's handling the PR is doing a terrible job. They should have left things alone, but now they've opened a new front that probably won't gain traction. Even legal experts are skeptical, suggesting the judge may not compel either side to act. And if they do, it could force both parties to make uncomfortable compromises. So what if Blake Lively never even gets her day in court? What if Baldoni's team has uncovered a legal shortcut capable of freezing the entire case before it ever begins? This isn't speculation, it's strategy. Baldoni's attorneys are using the law itself as their weapon, crafting a motion powerful enough to shut everything down long before a jury ever hears the first argument. Most people imagine lawsuits as drawn-out courtroom dramas, emotional testimonies, fiery cross-examinations, shocking twists. But this time, the real battle might happen quietly, behind closed doors, in the fine print of legal filings. And if Baldoni's motion succeeds, it won't just reshape the case. It could redefine how celebrity disputes play out in the public eye. In reality, the legal system can end a battle in an instant, if one side knows how to play the technical game. And that's exactly what Justin Baldoni's team is doing. Their latest move, known as a motion for judgment on the pleadings, MJOP, is one of the sharpest weapons in litigation. In plain terms, it asks the judge to make a ruling based solely on what's already written, the complaint and the responses, without introducing new evidence, witnesses, or discovery. Baldoni's lawyers are essentially saying, even if everything Blake Lively claims is true, it still doesn't amount to a valid legal case. It's a cold, surgical tactic, one that can eliminate a lawsuit before it ever reaches a courtroom. And the most ruthless part? Baldoni's attorneys aren't just asking for dismissal, they're asking for the case to be dismissed with prejudice. That phrase carries enormous weight. It means Blake wouldn't just lose this battle. She'd lose the entire war. No appeals, no refiling, no second chances. Once the judge signs that order, her lawsuit would be legally dead. Why such an aggressive strategy? Baldoni's team argues that even if Blake's entire version of events were accepted as fact, her allegations still fail to meet the legal definition of what she's accusing him of. It's like saying you were robbed but admitting that nothing was actually taken. An emotional story, perhaps, but one that doesn't qualify as a crime under the law. That's the legal trap being set. And if the judge agrees, Blake's case could collapse before it even begins. The consequences would be enormous. If the motion succeeds, there would be no discovery phase, meaning no exchange of private texts, no confidential emails, and no behind-the-scenes evidence ever made public. Everything that has fueled public intrigue, the whispered allegations, the rumored messages, the too close for comfort details, could disappear overnight with a single ruling. For Blake, that wouldn't just be a courtroom defeat. It would be a devastating blow to her reputation, reinforcing the idea that her case was driven more by drama than by legal merit. For Baldoni, it would be a quiet yet crushing victory, the kind that rewrites public perception without fanfare. And what makes this battle even more compelling is what comes next. The fight isn't just about what happened, it's about where it happened. The next major showdown won't revolve around testimony or evidence, but around jurisdiction, which states' laws truly govern this dispute. That decision alone could redefine the entire trajectory of the case and determine who walks away vindicated and who walks away erased. The question now is which state's laws will control this case, California's or New York's? That single detail could determine everything. If Baldoni's legal team persuades the court to apply New York's stricter standards, Blake Lively's claims could collapse on a technicality before she ever steps foot in a courtroom. In a battle this high stakes, every procedural move is like a chess piece, and this motion might be the one that ends the game before it even begins. Behind the scenes, the speculation is intense. Reports suggest Baldoni's side dropped a subpoena just before Blake was set to be deposed. They reportedly said, "We got what we wanted," leaving everyone wondering, what exactly did they get? The judge had already ruled that certain text messages were irrelevant, so the big question now is whether Baldoni's team already obtained them through other means, or if they're holding something unseen in reserve. There's also confusion about whether Blake can still be deposed at all. Some insiders believe there's still a narrow window of time, but the logistics are tricky. Could she refuse by saying, "I already gave my available dates and you didn't provide proper notice"? Possibly a day, and if she does, that could push the timeline past the court's deadline. If the cutoff date passes without a deposition, Baldoni's team could use that as further leverage in their motion to dismiss, arguing procedural non-compliance. On the other hand, if Blake manages to secure a deposition before the deadline, it could briefly revive her chances of being heard, but only briefly. Right now, every move counts. One wrong filing, one missed deadline, or one jurisdictional ruling could determine whether Blake ever gets to tell her story, or whether Baldoni's team quietly closes the case before it even begins. She can still be called to testify at trial later, allowing everyone to hear her version of events then, but she cannot be deposed past the court's cutoff date. Whether she's available or not no longer matters, because the judge has already ruled that the delay was caused by Baldoni's side, making the issue irrelevant. As for why this is all resurfacing 4 months later, that's a question many are asking. One theory is that Baldoni's team no longer considers the text messages as crucial as they once did. Back in May, those messages may have seemed significant, but their legal weight might have faded over time. Now, the attorneys may have realized they still need Blake's deposition to clarify key points, because going into trial blind is risky. No lawyer wants to ask a question they don't already know the answer to in front of a jury. One wrong move, one unexpected response, can completely shift the tone of a trial. But just as the deposition debate cools down, the legal spotlight shifts somewhere unexpected. Maps. That's right. Lawyers are now arguing about geography instead of allegations. It might sound absurd, but according to Justin Baldoni's legal team, this entire case could hinge on something as deceptively simple and deeply consequential as location. Here's the setup. Blake Lively filed her lawsuit in California, but Baldoni's attorneys claim that most of the alleged incidents occurred on the East Coast, specifically in New York and New Jersey. Why does that matter? Because California and New York follow completely different playbooks when it comes to workplace retaliation and harassment laws. California's laws are famously broad, allowing claims to proceed even when retaliation takes subtle forms, things like exclusion, pressure, or professional isolation. New York's laws, however, are stricter and demand stronger evidence of concrete harm or damage. It's like having two referees for the same game. California blows the whistle for almost every foul, while New York lets most plays continue. So the real question becomes, which referee gets to make the calls? If the court rules that New York's laws apply, Blake's case could be crippled before it reaches trial. But if California's jurisdiction stands, her claims might still survive the early motions. That's why the geography debate isn't just procedural, it's potentially case-ending. Beneath all the celebrity headlines and legal drama, the future of this lawsuit might come down to nothing more than whose map the court believes in. Under California law, employees are typically required to file a complaint with the state's labor board before pursuing a lawsuit. Baldon's attorneys argue that Blake failed to take that necessary step, a move that could prove fatal to her case. If the judge determines that California law governs the dispute, her lawsuit could collapse entirely on that procedural misstep. But if the court agrees with Baldon's side and rules that New York law should apply instead, Blake faces another significant hurdle. Many of the actions she's alleging might not even meet the threshold for retaliation under New York's stricter standards. It's a precarious position. A single procedural error or a narrow legal interpretation could wipe out her entire case. The situation underscores a larger question. What happens when one state's laws recognize your experience as valid, while another state's framework dismisses it entirely? Legal history offers stark examples. In one instance, a harassment claim that easily succeeded under California's broad protections would have been thrown out in New York. In another, a company avoided a massive judgment solely because the events were linked to a state with weaker employee safeguards. In high-stakes cases like this, geography doesn't just determine where a story unfolds, it can decide how it ends. That's why observers are closely watching Blake's legal strategy. Did she file in California because she genuinely belongs there, or because the state's expansive labor laws provide the most favorable ground? Baldwin's team is convinced it's the latter. They're moving forcefully to pull the case out of California, arguing that her choice of venue was calculated, not coincidental. For them, this isn't merely about defeating her claims, it's about changing the battlefield entirely so that the rules work in their favor. Even as attorneys argue over which state's laws should control the case, a subtler question lingers beneath the surface. What if this wasn't a matter of workplace retaliation at all, but simply another example of Hollywood's most common defense tactic, image control? What if what Blake Lively calls retaliation was, in reality, a carefully coordinated PR maneuver, a story spun out of control in the world of celebrity reputation management? If the judge sees it that way, then it may not matter whether California or New York law applies. Blake's case could end before it even begins, fading into yet another Hollywood cautionary tale. Her filing claims she placed key portions of Exhibit 1 into the public record, a move critics argue ignores the privacy of the man recorded without consent. Mr. Sowitz. His side maintains the full recording should be released to preserve accuracy and context. Sowitz, described as a man of Baha'i faith, a community known for peace and restraint, has found himself accused of shocking behavior, accusations that now sit at the core of Blake's narrative. One of her central arguments is that he and others were willing to ruin her, no matter the cost. Blake insists that what she endured was clear-cut retaliation. Justin Baldoni, however, counters that it was nothing more than standard Hollywood PR. And that's the heart of this growing legal spectacle. Who's telling the truth? Blake describes a deliberate smear campaign, targeted headlines, veiled public jabs, and whispered gossip meant to erode her credibility. Baldwin's lawyers respond that none of it was malicious. It was business as usual, the very machinery of entertainment promotion. According to them, the so-called attacks were simply part of a long-refined industry formula, the strategic use of controlled tension and narrative spin to generate attention. In Hollywood, controversy sells. As a film nears release, every quote, rumor, and offhand remark becomes part of the show. A little backstage drama, a hint of creative conflict, all of it fuels curiosity and drives engagement. For decades, publicists have mastered that formula, blurring the line between reality and performance. And now in the courtroom, that same ambiguity has become the central question. Was Blake Lively truly retaliated against, or just caught in the ruthless publicity machine that made her a star? Create controversy, spark conversation, and turn attention into ticket sales. That's the formula Hollywood has relied on for decades. Baldwin's team insists that's exactly what happened here. Nothing more than routine PR spun into drama, not retaliation cloaked in scandal. But the real challenge for the court lies in drawing the line. Can statements framed as mere publicity cross over into unlawful retaliation? It's a razor-thin distinction and one that could decide the entire case. If those comments were part of a legitimate marketing effort, professional, strategic, and aimed at promoting the film, they fall under the wide umbrella of free speech protections. But if their intent was personal, meant to punish Blake Lively for asserting herself or speaking out, that changes everything. In that scenario, what looks like harmless PR suddenly becomes a weapon, a tool for retribution disguised as press. Lively maintains that's precisely what happened. She argues the media stories and sound bites weren't random. They were deliberately crafted to portray her as unprofessional, difficult, even unstable. In her eyes, the campaign wasn't about selling a movie, it was about discrediting her. Baldwin's side, however, stands firm in their defense. They insist every statement made was constitutionally protected, part of a public discourse surrounding a high-profile project. When free speech enters the courtroom, the stakes rise dramatically. Judges tend to favor open expression, even when it cuts deep or damages reputations. That long-standing deference makes proving retaliation in cases like this especially difficult. It's a conflict as old as Hollywood itself, the eternal tension between publicity and punishment, between storytelling and smear. In Hollywood, trading playful jabs is part of the job. Actors, directors, and producers toss around lighthearted comments in interviews, half serious, half for show. One actor calls another a perfectionist. A director jokes about endless reshoots. Tabloids pick it up, fans debate it, and suddenly the movie is everywhere. It's performance marketing, entertainment disguised as rivalry, and it works. But what happens when one of those jokes stops feeling like a joke? When the teasing turns sharp, and the shade starts to look like a calculated attempt to discredit someone? That's the fine line this case now has to define. If the court finds that Baldwin's team was simply engaging in normal publicity, Blake Lively's retaliation claim could collapse. But if it determines that those remarks were motivated by personal animosity, a deliberate effort to punish her for speaking out, that same PR could legally be considered targeted harassment. The implications reach far beyond a single lawsuit. The court's ruling could reshape how Hollywood handles controversy in an era when every comment, clip, and headline spreads instantly. A decision in Blake's favor could set a groundbreaking precedent that even subtle PR tactics become retaliation if intent crosses the line. A ruling for Baldwin, however, would reaffirm that free speech in film promotion remains almost untouchable. Either way, the outcome will echo through red carpets, press tours, and studio boardrooms for years, redefining how stars navigate the perilous overlap between publicity and personal reputation. Meanwhile, Baldwin's legal team has filed a motion for judgment on the pleadings, essentially asking the judge, "Have you seen enough? Can we end this now with prejudice?" In plain terms, they're pushing to have the entire case dismissed before it ever reaches discovery.